I'm Daniel Roberts. The subject has come up. What about changing your career area? What about changing from one practice type to another practice type? Can it be done? Has it been done? What are the issues involved? I answered this question in a recent interview, and here it is. I hope you enjoy it. Have a great career.
How difficult then is it for someone, so they've done the criteria filter, they realize the type of law that they're practicing is not, they really actually have a high curiosity about a different type of law. How difficult would it be for someone to make a shift from one area of the legal profession to another?
It depends. It depends. If you're young and you need to be employed and you've started off in one area, sometimes it's hard to make a shift over. For example, if you're with a firm and say you're a litigator, you're two, 3 years into your career with that firm, you decide you don't want to be a litigator, it might be pretty hard to change over to another department. But it just depends. And the people that run the firm, the managing partner and the board, they're going to look at it, and if you've got talent and you've got good reasons and they want to keep you, then there's a good chance that they'll at least consider it. But that is a bit of a challenge when you're at that level. And as you get more specialized and you get further up toward partnership, and then as a partner, it's just really not heard of that I know of that you actually change the area you work in. You might be able to refine it a little bit. You might be in banking, and in general, you might be more general, and then you might get into more of banking in the public sector, and offerings and so forth, high finance. But generally, it's more difficult. But if you're with a small firm, or if you're on your own, yeah, you can do it. Absolutely. I worked with an attorney in Texas who was board-certified medical malpractice attorney. He had tried cases for 25 years, was really good at it, liked it, and they changed the law. And they made it so that it was just not as financially feasible to try medical malpractice cases. So he had to decide what to do, and I helped him think through that. And so what he did was he turned to the probate area. And since he was a board-certified litigator, he was crackerjack in court. A lot of probate attorneys they're not litigators. They don't do that. They appear in court, and sometimes they have contested issues, but they're not really at the skill level that he was. So he was able to attract clients, and especially referrals from other attorneys, when there was a contested probate matter, because he knew how to try a case.
Right.
So that was half of it. And then the other half, his other profit center, was he did estate plans, wills and estate plans. And this brought out the business side of him, because he had paralegals, he had secretaries, he had the forms, he had the procedures, and it was like a factory. He would meet with a client, he had it down to the minute almost, how long it should take him to do it. Meet with the client, get the information, fill out the forms, pass it to paralegal number 1, they do this, he looks at it, pass it to paralegal number 2, they look at it like this, they call him, they come in, he does it, everything's signed, done, bam.
Wow.
And so the beauty of it for him was that he had the estate planning and probate. He also administered probates, after people died, and he had the cash flow from the probate side of it, and that was good. And then he also had some, but on the other side, he had trials. But those are, even though you get paid on your fee on your hours, you don't get it. It's not as steady.
Right.
So between the two of them, he made good money. He made good money. Not as much as making a lot of money on a medical malpractice case, but he wasn't in court as much, and he was happier. So absolutely, you can do it. And so at any stage in your career, you can revise your law practice. And you look at it just like your corporation. You've got different profit centers. And you say, okay, so what do you want to do? What do you want your practice to be like? And we work in it in detail. We say, for example, well, someone might say, well, I want to do 25% corporate and business transactional. I say, okay, great, and where are you now? I'm at probably 10%. Okay, we got a 15% gap we need to do. What else do you want to do? I want to do personal injury defense work. Where are you right now? I'm at 40%. Where do you want to be? About 40%. Great, you're there. We don't need to work on that. And what else do you want to do? Well, I want to add mediation to my practice. Where are you now? Nothing. Oh, okay. So you want to start a whole new practice area, new profit center. What do we need to do? Well, I need to get the training. Well, I need to get the word out. I need to get, and we have a plan then. So in each area that we have a plan for how we help how we get there. And it depends on what the gap is, but the idea is to bridge the gap. And some areas you're going to cut out. So, I really don't want to do that anymore. I don't like it, and I'm not making that much money, but I think I'd like to do this. I think I'd like to add immigration law, or I'd like to add, something else, banking or whatever. Then you just see what you do, you figure out how to get them there, and you do it. So absolutely, and as one progresses in the law, oftentimes one gets tired of litigating cases. Yeah, a lot of attorneys practice litigation law because there's a lot of business at first and it sounds really exciting. After a while, it's not so exciting. So I find a lot of attorneys come to me that are litigators looking to do something either instead of or in addition to the litigation.